Hello and welcome to the consultation. My name is Christina Jimenez.
I'm Julie Prentice.
I'm James Palin.
And we are attorneys at the Jimenez Law Firm. We have, how many combined years? Like 20 plus 25. Oh man, I'm aging myself. But we have a lot of years of experience in family law and criminal defense. Every Friday we host an event here on Facebook Live where we talk through complex legal issues, family law and criminal defense, because that's mostly what we do. We tell people at the beginning, middle, and end of this stream, please, please, please do not accept this as legal advice. You're going to see as we're talking through these fact patterns, we're kind of just talking about ideas and kind of random opinions and things that we think that a court may be inclined to do or not do, talking about it from different lawyers' perspectives and client perspectives, etc. But it's not legal advice, right? It's more of just like a group of friends talking about some things that may happen in the future. So if you find yourself in a situation like this where you might need an attorney, please find an attorney that practices in the area where your case is going to be heard and follow his or her advice. Okay. Also, if you could follow us on Facebook, TikTok, LinkedIn, I don't know where else, but all those places, if you could follow us on social media, we would greatly appreciate it. And if you think that this information may be helpful to anybody that you may know and love, then please send it over to them. And so with that being said, do you guys, did I miss anything? No, we're good.
Instagram and Twitter.
Thank you. Instagram and Twitter. Thank you. So with that being said, who wants to read first?
Ooh, I love to read.
Okay, go for it, James.
Okay. So what are the downsides of utilizing a collaborative law process for child support? Is check garnishment possible? The couple.
Wait, yeah. What questions are you reading, James?
I thought we were just coming up with them off the dome. No.
Are you looking at 9/9/22 or are you looking at 9/2/22?
All right, so that was the warm up just to get everybody's mind preface.
Just to get my heart pumped in because I didn't have that question. Okay,
okay, all right, now here we go. Take two. Can I get a temporary adjustment for child support when between jobs? Okay, I am due to retire from the military soon. I'm in the process of applying for other jobs, but do not have one lined up yet. Is there any way that I'm able to get an adjustment or put a temporary hold on my child support amount? I have a very small amount of retirement that will be coming in. That will be my income at the moment, but won't have a normal paycheck.
Julie,
thoughts, ideas?
So I think you can, whether you should or not is another question. So to modify child support, if there has been over 3 years or a 20% change in income or $100 change in income, up or down, either way, or a material or substantial change in your circumstances, then you can modify child support. That being said, there's a difference between can and should, and I don't know that you should in this case. It's not going to be very cost effective. I mean, if you get a job in a week, you're going straight back.
Yeah, so hold on. There we go. Sorry, guys. My computer's like all sorts of glitchy, so sorry if I'm looking and sounding weird. So, I mean, yeah, I guess he could. And I guess it depends on how long he's going to be unemployed too, right? Like if he's going to be unemployed for 6 months and it's going to take him that long, then it may be a good idea. But most judges, if it's like, and I've had that happen a lot where people come in for consultations and they're like, well, I just lost my job last month and I'm still looking, but I don't know if I'm going to find something. I want to go today and modify my child support. a lot of the judges, if you've just been out of work for like a month, they're not going to, guys, am I like weird looking? Is it like completely butchy
No,
now?
you're good so far.
I look very strange from where I'm sitting.
Knocking on wood now.
And so a lot of judges won't do it. I mean, a lot of judges will say, it's just a temporary thing, and you have, for the past 10 years, you've been earning $100,000 plus. Just because you've lost your job and you've been out of work for a couple of weeks, not going to modify it. I normally tell people like 2 or 3 months. If you haven't been working, then maybe that's something that the court will consider. But I don't know. It's kind of hit or miss. I think it depends why also. Like if you have some sort of an injury and that's going to prevent you from being able to work, then yes, the courts might be more inclined to reduce your support. If, I don't know, you've lost some sort of a certification or something, and so you can't do whatever it was that you had previously been doing, and you're going to have to take a big pay hit, maybe that would be another reason to try to do it on a temporary basis. But yeah, I mean, if you're just kind of looking and it's been a couple weeks, I wouldn't waste my time and money doing it.
Quick question. So he said he's retiring, right? So yeah, I see the temporary. Yeah, you can retire from the military at a relative young age. But if indeed this is someone who's in their golden years and looking to live off that fixed income of retirement, doesn't make more sense then.
I mean, yeah, if it's just going to be off the retirement, because he's saying it's a very small amount. And so if that's his plan, is just to straight up retire and that's going to be his only source of income, then yeah, he can file and he'd probably get it. But I mean, all that's going to happen is as soon as mom finds out that he's going back to work, that she's going to take him right back and increase it. And so, but he might get some temporary relief. And if mom doesn't find out, well, then I guess that's going to be, he'll get away with it for an extended amount of time, maybe. But I don't know. It's a lot of back and forth for me. I try to keep things simple if we can. So, but yeah, he could do it. He might get it. I would actually think that would be interesting if he was like, 45 and he's retiring from the military and he just says like, I've done what I needed to do and I don't want to work anymore, Judge. I don't know. Would that be intentional underemployment or intentional unemployment?
Right. But who's going to argue with the military guy saying, no, you need to go back to work?
I mean, who do I represent? If I represent mom, I might do that. I mean, no, and I don't know what a judge would do.
Okay.
That would be an interesting argument, intentional underemployment, because that's the thing. And I guess we can kind of talk about that. So I've had that happen and I've been on both ends of this thing where, I have a guy who's a freaking surgeon and he's like, well, I'm not going to pay her $2,500 a month in child support. I'm going to go work at McDonald's. And I'm like, well, that's a nice theory. Nice plan, except that the court, if you make a decision like that, the court can always make a finding that, listen, you have the ability to earn, $20,000 a month, and therefore you have the ability to pay $2,500 a month for child support. It's your choice, and as you're doing it intentionally to take a job where you're going to be paid less. And because of that, we're still going to keep your child support obligation at the $2,500. And I've seen it done. I've done it. Right? Intentional unemployment, because I've had guys that are just like, I'm not going to work because I'm not going to pay your child support. Or I'm going to pay the minimum wage guideline support. And that's it. And then if you can establish, well, no, he's always worked. He's always had a certain amount of income. And we have, most of the time, because people are not bright all of the time, they'll send text messages saying, I quit my job because I'm not going to pay you. Yeah. Those are always helpful in an intentional underemployment situation.
Yeah.
So, and we normally will have something like that. So you take that combined with their work history, and judges are like, yeah, I'm gonna go ahead and make you pay, X number of dollars. So, but I don't know in this situation, because you're right, James, like, I don't know that I would.
Underemployment with the military servicemen, yeah. Ouch.
I don't know, maybe I would have made the argument. And I don't know what a judge would do, but it's an interesting, I guess, an interesting issue. So I don't know.
Okay.
But if it's just for temporary relief or temporary, just while you're looking, a lot of times the amount of money that you're going to save in your child support would actually be less than what you're going to pay an attorney to go in and modify it. And so, I typically do the math, right? And I just say, all right, you're going to save, hypothetically speaking, a couple $1,000s, because realistically, you're going to find a job within the next couple months. Don't waste your time and your energy messing with lawyers and all this nonsense, right? Because then, Lord forbid, now that I'm thinking about it, what happens if he does it and then they do some sort of a temporary order, and then he gets another job and he gets a job where he's making X number of dollars, plus he's getting his retirement, and then his child support ends up going up at the final. So that would be my other fear. That might backfire a little bit. So,
Okay.
yeah,
All right.
maybe not. No.
Sorry, G.I. Joe. Next time.
Right, don't do it. Okay, who wants to read the next question? This is the long one. My gosh.
I'll read it.
Okay, have fun.
Thanks. How can someone get back their parental rights after being tricked into signing them away to grandparents? My roommate gave birth to her son 2 years ago via C-section. Not sure why that part's important, but there you go.
Yeah.
Well, she was still a little out of it. Her parents brought her some paperwork saying it was from the hospital and had her sign on the dotted line. Come to find out, she signed away her custodial rights to them, unbeknownst to her. Since then, her parents have tried putting her on child support and have used her son as leverage to get whatever they want from her. They collect her Social Security income checks every month, and she doesn't see a penny, and they collect child support from her. They recently kicked her out and moved her son an hour away and refused to let her see him, but maybe once a month. She wants to get her rights back, and come October 31st, their rights as custodial parents end. Sadly, knowing her parents, they're going to be on top of that and will do whatever it takes to make sure they keep the child in their custody. I don't know if it's relevant, but her mom once asked her if it was all right to get attached to the child since she didn't have a relationship with her own son. Now it's like she thinks that child is her own and not my roommate's. What can she do to get her son back and prove that her parents aren't fit to be parents to him?
I'm confused.
Yeah, me too.
Mm-hmm.
What, I guess maybe she just signed like a SATSR order?
That's what I was trying to figure out. I mean, if
It wasn't a voluntary relinquishment. I couldn't have been.
I wondered if this was Texas.
Yeah.
So maybe it was what's the temporary guardianship?
Maybe. Because it doesn't make sense that the rights come to an end October 31st.
Right.
That doesn't make sense.
And that she still owes child support.
Unless it was maybe a temporary order that never got put to final.
For 2 years.
I mean, that could have happened.
That they just happen to have handy at the hospital. That's a lot.
Yeah, so this is gonna be one of those cases where we're gonna have to see the paperwork. We're gonna have to look and see what was actually signed, because this is all so number one, I don't think it could have been a voluntary relinquishment of parental rights, okay, which I think is where I thought this thing was going based on the initial question. So An affidavit of voluntary relinquishment is a document that a parent signs, basically saying, I want to give up my rights to my kiddo. And if I remember correctly, they can sign it. They cannot not sign it any earlier than 72 hours, I think it is, after they give birth. And so if they sign it 72 hours, within 72 hours of giving birth, then it's actually not valid. It's going to be void. But if they sign it 72 hours after they have the child, that is a valid relinquishment, and then you can move forward with the termination of parental rights with that. However, that needs to be signed in the presence of a notary and also in the presence of 2 witnesses, which that doesn't seem like something that went on here. And I don't think they could have like just tricked her the way that they're saying. So I don't think it was that. That's good. It could have been a temporary order, James. I mean, in theory, and it could have been maybe like well, not a global waiver of service. Maybe a temporary order, because you could file it like, I guess, while she was a little out of it. They don't say that it was like immediately after birth. So she could have been out of it like while she was still in the hospital recovering and stuff, right?
Well, she was still a little out of it. So she was under some sort of sedation.
Mm-hmm.
That's,
So if it was
Yes.
a temporary order, I guess it could have been that. That would be tough to pull that off. So what I would say is I would want to see the paperwork. If they're saying something to the effect of the rights end October 31st, then what I would probably be looking into is some sort of a modification, right? Either of a temporary order of a previous order, and fighting for mom to get her parental rights back. Right? I mean, I don't know. What else is there? I think it sucks. I don't understand why we're waiting until the kiddo's 2 years of age to be able to, or to file something. Like, what's going on with mom? That's kind of weird, right?
right. So she was living with him. I think that's part of the issue, because it was, hey, look, if I'm living with you and the kiddo's living with me, we're all living together. So the rights are running in the same direction.
Mm-hmm.
It really didn't, in my, you know what I'm saying? Because I got to read through the lines. You see what I'm saying? I have to decipher what it's really saying behind the black and white.
There you go.
So
That's what I do, James. And she always talks crap about it, but you have to do that. You have to take liberty with the facts. So I'm okay with this. Go ahead. Go ahead.
One of the
Where you
things that's
learning from?
trickling down through the mentorship is what's happening. But so the issue, I believe, arose when she got kicked out. So now kiddo's not with mom, mom's not with grandparents. And she's like, well, wait a second, what's that thing y'all I signed? Wait a minute, I have to pay y'all. And I'm still interested though, because they would have had to prove up all of that: child support, conservatorship. And it sounds like mom doesn't have any possession or access.
Right. Yeah, and I mean, I think if it was a temporary order that was signed, that's something that can be remedied at a final, right? I think with it, assuming that that's on October 31st and you go in and you have a contested final trial, you can explain to the court the circumstances under which you signed the document, the fact that you guys haven't been following that document this entire time, and they have recently kicked her out, etc. Right? That can be remedied. If it was for some reason a final order, which wouldn't make sense, maybe filing some sort of a bill of review, maybe, to try to get that thing set aside, but I don't think it was a final because of that October 31st thing. So, but I like that argument, James, of, okay, I signed something, but we never followed it until they got pissed off about something. So, that sucks. Yeah, we need to know what you signed, and then from there we can probably figure out what we can do to help you, or what an attorney can do to help you, not us. So maybe us, I don't know.
Yeah, you're a local attorney, right?
I'm like, I need to know. I need you to send it to me now, please.
Yeah.
But yeah, so, all right, next question.
Am I to read again?
I'll read it. So my son-in-law filed to modify his parent-child relationship, but the case was dismissed for lack of prosecution. He is the better parent. For some reason, correspondence sent to him by the court was returned as undeliverable. He lives in a different state, Oklahoma, than my grandson, who lives in Texas. My grandson's stepfather abuses him. Recently, my son-in-law requested copies of the documents. Will he be able to refile to modify?
Okay. So he filed in Texas, right?
Mm-hmm.
Well, yeah, I don't see why he shouldn't be able to file again. But
Right.
my grandson's stepfather, grandma's writing this.
Mm-hmm.
Okay. I'm just trying to get the parties together. So yeah, I mean, I don't see why he shouldn't be able to refile, get the right people served, get in front of the court, make his case.
Yeah, so this is actually mom's mom, right? That wrote the question on behalf of dad.
I thought it was dad's mom. Yeah, okay.
So I think it's mom's mom that wrote the question, and well, no, maybe it is dad's mom. Hell if I know. Anyway, the short answer is yes. If the case is ever dismissed due to non-prosecution or want of prosecution, you can always refile. It sucks because you have to start the whole process over. You get a notice of non-suit or notice of dismissal. Normally it's not with prejudice. If for whatever reason it's dismissed with prejudice, then that is something that would have to be corrected, because that would really suck, because that means you can't refile. But in SAPSER cases, you rarely, if ever, see that. And then, yeah, you just start over again from scratch and pay your filing fees and pay your service fees, and it's gonna suck, but yeah, absolutely. So Floyd, if you're not going to be joining us, then you're not allowed to talk crap on the comments. I'm just gonna say,
What did he say?
That it is 72 hours and that we need to get it together. And that's it. So yeah. Okay, number 4. Can I file for divorce out of state? Julie, you want to read this one?
Sure. I recently found out my husband has cheated on me. We live in Texas. Prior to me finding out, he has been emotionally abusive to me throughout the whole marriage. I couldn't take the mistreatment of me and our children. I am at my parents' house to spend time and then asked my husband if he and the kids can stay for my mental health. He agreed, and now because I told him we can be cordial and that I don't want to be friends, he wants to threaten me about bringing the kids back. Can I file for the divorce out of state?
So they were living in Texas and then she moves out of state.
Yes, ma'am.
She moved out of state. So it depends. Every state, well, yeah, this is a lot.
It depends on the jurisdictional requirements for each state and what state you move to.
Right.
Local council.
Right. So in Texas, you have to live in the state for 6 months and in the county for 90 days before you're allowed to file. I don't know what every other state, what the jurisdictional requirements are. So that's kind of the first issue is, can you establish just general jurisdiction to be able to file? And then you also have the issue of, has dad ever been to that state, so that you can get personal jurisdiction over him? And it's not just him being there. There's lots of different, what we call in Texas, long arm statutes, right? So We want to know, has he ever been there? Did he agree for the kids to go there? There's all sorts of, what are the other long arm jurisdiction elements? Do y'all remember? It's like a whole list of stuff.
Right,
We
maybe.
have sexual intercourse in Texas. Does he have a business or, yeah. So there's all sorts of different ways that we can get personal jurisdiction over someone. And that's important, especially when you're dealing with kiddos, because the only way that you can make him, like oblige him to do something is if you have personal jurisdiction. So if you want child support, you're going to need that. And if you want to divide assets, you're also going to need that. And so could you potentially? Yes, but it might not be the smartest thing to do. So what do y'all think happens if she files in Texas?
If she moved away and left the custodial parent or the other parent in Texas, it's probably not a good day in court.
I mean, I'm at my parents' house to spend time, and then asked if my husband, if we could stay for my mental health. He agreed. And now, because I told him we can be cordial, or that we cannot, I guess is what she means. We cannot be cordial. He's threatening me. So I don't know. Like, I feel like whenever a parent agrees to allow the other parent to move, a lot of judges are not really sympathetic if you try to get the kiddo back. So I think that if dad had agreed to allow her to stay, I don't think that's a good case for him, depending on the court, right? No?
I could see that. I read it as took a vacation and then just stayed, but you're right with the agreement part. It may make it a little harder.
Right, but I think the circumstances still change, right? Where we're in a positive relationship and she says, well, no, we can't be cordial, we can't be friends. Well, how am I going to get to see my kids? How am I going to get to FaceTime them? How am I going to get pictures? How am I going to get updates? The things that were going to make me comfortable with you moving out there.
That's true. And I also think that it depends on how long, he agreed, right? And we've had that happen before where, a dad agrees and then kind of a similar situation where things kind of fall apart after a couple of weeks of him agreeing. And then he comes in and he hires us and he's like, what do I do? And immediately it's like, well, we don't agree to this, right? Like, you need to bring the kiddo back or the kiddos back. And I made a mistake. I was hoping we could reconcile. I was hoping you would, be a better co-parent. And then we try to get them back. But if it's been like months, I think he's toast. I don't think there's anything you can do. But weeks, I think maybe you got some.
And so I was going to ask if you feel like there is a large difference between perhaps getting a rush divorce, pro se divorce, and allowing for one party to have the exclusive right to designate the resident. And then after that's all said and done, that party goes and moves out of state to this situation where they have not had anything done formally in the courts, and she just moved.
So wait, are you saying like the divorce decree's been signed, or it has not been signed?
The divorce decree has been signed. One party has that right to designate the child's resident and then moves, versus this situation where it's sort of the beginning stages. And they take the kiddo and move without that right.
Well, I mean, if the decree doesn't have a geographic restriction, then they can move and they're not going to get in trouble for moving. And so, and we've seen that happen several times. And then you have this like rush to the courthouse of, oh, I want a temporary order to say that she can't move out of state. Even if the final decree says that I can. or she can, and the judges cannot modify that on a temporary order. The judges cannot enjoin you on a temporary order from being able to relocate if there's a decree. So if she had that, I think she'd be great. In this particular case, I think it's kind of a toss-up. And I think this whole idea of I'm gonna go visit my parents and then I'm gonna just stay. I don't think judges normally like that. I'm kind of with Julie on that one. But if he agrees, maybe you got a chance. What do y'all think about the fact that he cheated on her?
Was that in here?
Well, she recently found out that her husband cheated on her.
I mean, infidelity is not good.
Divorce.
I agree. Except, do y'all think that it has an impact on conservatorship or visitation or anything?
I think it's gonna depend on your judge. But if it's in the court of James Palin, then absolutely. I mean, when it comes to, I'm just kidding. But I think it's a local, it's a local thing you got to work out. That's why it's so important to find those local attorneys who know what that judge is going to do.
Well,
Yes.
I think the impact of the kids, I think it depends on the impact of the kids as well. If it was a one-time thing on the side and he's still a great dad, I don't think it plays as much as to custody. It might play to property division, but I think a lot of that has to, I mean, now if he's dating someone else, introduced him to the kids and spent overnights, that might be more of an issue.
Right.
But if there's not a lot of going on with the kids, it may not be as effective.
Yeah, so we used to have a judge, he's not around anymore, but if a spouse cheated and you were in his courtroom, you automatically, everybody knew you were gonna lose custody. And there are judges like that. And so to y'all's point, like knowing the judge and having local counsel is a big thing. I'd say in my experience, other than that judge, most of the time, I don't know that when people have affairs that it really impacts conservatorship. I mean, unless like you're saying, so we've had where, you know, mom's dating her new boyfriend's a registered sex offender. Clearly, like that's easy. You know, new boyfriend has criminal history or girlfriend criminal history. They're, you know, have drug charges. They have family violence charges. They've had a protective order rendered against them in another case. Like all that stuff, that's all easy. Yeah, probably not best life choices, which would end up resulting in dad, or excuse me, in this case, mom getting conservatorship. But if it's just they were having problems and he went and he cheated and that was the extent of it, it doesn't matter. It makes him a bad husband, not a bad father. And most judges are still going to let him fight for conservatorship and may give him conservatorship. So that's my opinion. Thoughts?
I think that's right.
So yeah, it sucks. And obviously, and it's always, that's a very, very, very hard conversation to have with someone, because the obvious argument is, well, they clearly were not thinking about their children, right? They weren't thinking about best interest of their children when they had this affair, and they destroyed our family, and the kids' entire, you know, lives are going to be uprooted because of their decision to have this affair. I understand the argument, and like emotionally kind of the issues with all of that. It's just not something that a lot of judges will take to the bank to say, okay, you get reduced visitation or whatever. It's not going to happen. You could probably get an injunction against the mistress. Like we've done that before, like the new girlfriend can't be around the kids. And depending on the circumstances, we've had that be like a permanent injunction, which really makes it difficult for them to continue that relationship. But yeah, Can she file for divorce out of state? Depends on how long you've been there. Go talk to an attorney there. So, next question.
Next question.
Alrighty, who's gonna read?
I will. In Texas, I have temporary custody orders for a child custody case. What happens to those orders if this case is dismissal for want of, I'm assuming, prosecution? My niece is 14 and I'm fighting the mother due to abuse and drugs and was given temporary orders from the judge. Will those orders be canceled if the case is dismissed for want of, I'm assuming again, prosecution, not persecution?
I mean, they may want to persecute as well.
I mean, that might be a thing.
But yes, those orders will be canceled. So do not let it get dismissed, because what happens if it's dismissed to this little girl? Anybody know?
CPS.
Equal rights when we start over.
Yeah, I mean, if they don't have any orders, then presumptively at that point, mom could go and try to pick up the kiddo and keep the kiddo. And if there's no orders that are in place, she will likely have a good chance of actually getting her. And I guess you could call CPS, like you said, James, and maybe CPS would get involved and do a safety plan or whatever. But it would just be a freaking nightmare, an absolute
I wouldn't
nightmare.
recommend it, but it's an option.
Yeah, you don't want to do that. And even if like the aunt who has temporary custody, if she had any sort of CPS history or drug history, getting the department involved, they could say, well, we don't really think that it's best for this kiddo to stay with you because of your history. And then we have problems. So you got to get this thing finalized and get a final order. Otherwise, mom's going to cause you some big problems. So, and what happens if it gets dismissed for whatever reason? What should the aunt do?
Refile.
Mm-hmm.
Yeah, just refile, do a TRO, extraordinary relief, and go from there. Do it again, all of it. And don't let it get dismissed.
This is interesting. This is like the second question we've had like this. So, and one, I don't know, that we don't really come across a whole lot. Most of our people are like, yo, let's get it done. Things are going too slow.
Right.
So this is just interesting that, people are so interested in what happens if you kind of just let it sit.
It happens a lot, unfortunately. And sometimes for strategic reasons, people just let things sit, right? So with this aunt, that attorney may have said, let's just write out these temporary orders for as long as we could, right? Because you have the child and maybe mom didn't have access, etc. So we have cases that get set on VWAP, and we know they're going to set on VWAP. And when they do, we get it set for final trial and then we go from there. So, yep. Next question. James, you want to read it?
Sure thing. What is the penalty if you're 17 and cut your ankle monitor off in Texas? Man, I hope those Google receipts are not on with this one. My goodness. Asking for a friend. All right. My brother was on the monitor for 5 to 6 months and on the run for 2 months. It started because he began dealing with very bad stress. He couldn't sleep. He would wake the house up at night and we would see him crying. He got fired from his job because of the ankle monitor, and everything and everyone around him just kept putting more and more pressure on him. He tried therapy, but that didn't help. He was getting drug tested and passed every time. Then one day he cut off his monitor. He was on it for an evading arrest, I believe, and theft. That was his first time cutting his monitor off, but the second time on it in different situations. Just needed to know the penalty of this case. What do y'all think? Julie?
Yeah, I'm gonna go with Julie on this. Phone a friend, Julie.
So it depends if it was put on as a bond condition or if it was put on for probation. If it was put on for a bond condition, then he's gonna have a warrant out for his arrest and he'll have to go answer for that. He'll get arrested and then the charge will go forward. If he cut it off while he was on probation, then they're going to file to revoke his probation. And then it depends on if he was on deferred probation or straight probation at that point. Or actually in Ector County, sometimes you can actually get the monitor instead of going to jail. So if he cut it off and that was the case, then he's going to go serve the rest of his sentence, whatever it was in jail. If it was cut off, then as a condition of probation, then he'll have a hearing where they will have to prove that he cut it off and he violated a condition. And then if it's deferred, then in that hearing, the judge would have the full range of punishment available. And if it's straight probation, it depends on how many years he pled to. If it was 2 years probation, the judge has that as an option. If it was 5 years probation, then the judge has that as an option.
Yeah.
He's in some trouble.
He's definitely in some trouble.
It sounds like he has some mental health issues, no?
It definitely sounds like he has mental health issues. And hopefully he has a good attorney to bring those to the attention of the prosecutor. But normally judges are pretty upset by the time you're cutting monitors off. And you're probably sitting in jail until there's at least a hearing.
That's sad. Very, very sad. But yeah, I mean, and I'll just say, like, when I do a lot of this criminal defense stuff, I will have like very real and very tough conversations with clients about, are you going to be able to keep up with this probation, right? Are you going to be able to stop smoking? Are you going to be able to, follow all these rules and your curfew and all this stuff? And if they can't, sometimes it is better just to do your time, get it over and done with, and move on with your life. Because, we've had several clients that they get revoked, they sit in jail, for 30, 40 days, and then they come back out. And then they're out for a few months, and then boom, they get revoked again. And it's just this back and forth and this extension of probation for years and years. And it's just like, is it really worth it, right? By the time you get through all of that stuff, you could have just sat out your time and then been done with it. So something that people have to think about when they sign up for these crazy things. It sounds good in short term, but it's not always going to be the best thing holistically for your life. And this guy, I mean, he's going to get into more trouble probably than what he would have if he had just done what he needed to do. So that sucks. Sucks. So go ahead, James.
I'm sorry. I was just curious. So Julie, I think the latter situation you described, like this is how he's serving his sentence, right? Mm-hmm. Is it possible for his attorney to go in and say, well, hey, look, he can't make money. I know this essentially is his sentence, but is it too late at that point to look to modify?
So normally by the time that's your sentence, they have modified. So it's very difficult to make that argument. Normally by the time you're on a monitor, that's your second or third chance. And so if they're doing that, you've already made that argument. That's how you got the monitor in the first place. And then he cut it off on top of that. And so then you're in trouble.
Maybe it fell, nothing lasts forever. Take a shower,
But
that
the answer
soap can be harsh.
But the answer is you can always try.
Okay.
Worst they're gonna do is say no.
And the other thing that I was going to say is a lot of times when I have these types of situations, and I do believe that it's a mental health issue, I'm immediately trying to get some sort of, inpatient treatment, some sort of evaluation, something to try to prove to the court, like, listen, this was a extreme situation. This is not, his normal behavior. He maybe had a mental breakdown, whatever it was, to try to give either the prosecution or the court something to consider to get this individual out of this situation. Because clearly to do something that desperate, like he was in a bad spot, very bad spot. So something to think about.
Definitely.
Next question. Number 8. Who wants to read?
I'll read it. My ex wants to voluntarily terminate his rights. My husband is wanting to adopt a child. How do we go about it? My ex doesn't want to pay child support, so he wants to give up his rights, and my husband now wants to adopt, I'm going to say the child, not just a random child. Will this interfere with each other?
No, this is actually something that we do quite a bit, unfortunately. I guess fortunately, I don't know, whichever way you want to look at it. But that is something that we see a lot. So one of the things that I've seen is when the dads actually call me and they say, hey, I don't want to pay child support anymore. I want to file a motion to terminate my own rights. And that's not really a thing. And it's not a thing that most, if any, judges would ever grant unless mom agrees to it, right? So if mom agrees to it, then that we can definitely move forward with that. But if mom doesn't agree, then you're on the hook for child support and it's your kiddo. And I'm sorry, nothing we can do. In this case, though, if he's willing to sign an affidavit of voluntary relinquishment, he would sign that paperwork, you would process the termination, and effectively, once those rights are terminated, he's not obligated to pay child support. However, I will say that I had a case, super, super frustrating, but it happened. So in this case, dad, kind of the same situation. He didn't want to pay child support, and mom had made his relationship with the kiddo pretty difficult, and she wanted the new husband to adopt. And so they tell him, will you please sign this affidavit of voluntary relinquishment? He signs it, and then he's not represented by counsel when he signs it. Mom goes in, she does the termination of his parental rights, and no, scratch that. So she files the termination paperwork, but she doesn't get the order signed until like 18 months later, after he initially signed his affidavit of voluntary relinquishment. And so what is happening in the meantime? They're still garnishing about $1,000 a month in child support, because the AG doesn't know that he signed this affidavit, right? And so in his mind, he's like, well, my rights have been terminated because I signed this piece of paper, and therefore I should not be on the hook for this child support. And mom and her attorney, they wrote it out for 18 months. That's 18 grand that he had paid. And finally that order of termination gets signed, and then that's submitted to the AG, and they stop collecting child support. And so he comes in and he hires us, and he says, you know, hey, they took $18,000 from my paychecks. I want that money back because it's not fair, right? And so we had to go in and we had to argue, like, basically an equitable remedy under contract law to say, look, judge, he signed this, he signed it under the pretense that his child support obligation was going to stop, and now we want to recover this money. And so judge ended up giving us most of the money, but did ding him a little bit because he waited so long to hire an attorney to file the paperwork and to do all that. And so if you're going to do this and you're the dad, I would encourage you to make sure that you have an attorney, because you want the paperwork to state my support stops on this day. I'm not responsible for child support, medical support, uninsured medical expenses. I'm zeroing out everything that I owed in the past. Very, very specific language. Otherwise, you're going to find yourself in that situation and you're going to get screwed, and it's not going to be fun. So sorry, that was a long story, but I think it's important, because when that happened, I was like, this is crazy. And I had even called mom's attorney and I was like, hey, you know, I think y'all kind of screwed up here and don't think y'all really meant to do this. And she was like, no, we did. And we're not giving him the money back. I was like, well, okay, if you're not going to get it, I guess we're just going to have to take it. Oh. Yeah, kind of shady. That was crazy to me. So Yes, you can do it. Do the right thing. Keep your word. Stop the child support, and then everything should be good. So, and then your husband gets to adopt, and everybody's happy. So, next question.
Okay.
Yeah.
Yeah.
I'll read. Can the father of my child use my OnlyFans account against me? I just need to know if the father of my child can use OnlyFans against me for custody reasons. I know it's not the best, but I have to do what I have to do, but I still want full custody. James, I'd be interested to hear a man's perspective.
All right. So depending on what you're doing on OnlyFans, I mean, I'm not just going to assume that any of the activities that you conduct within that site are nefarious or otherwise not PG-13. Okay. So
Isn't that what OnlyFans is though? Like not PG-13?
but it didn't start off that way.
Oh,
So
really?
brief history, a young man by the name of Malcolm, I'm just kidding. I don't know the history of OnlyFans. And honestly, I don't know what it is. For all my family members and friends watching this. So
You do only because you work here, right? Only because at the firm, because our clients we've seen it through them, James. I
Finish that
know.
disclaimer. Finish that disclaimer.
Right. But let's take it a couple ways. So if indeed there are some non-child friendly activities going on within that OnlyFans account, I mean, I wouldn't put it past some counsel to bring that up in front of the judge. Hey, judge, this type of lifestyle isn't what I want to exhibit as an example for my child and my children. And the types of activities that she's engaging in, my son or daughter's peers are able to access this, and he's subject to embarrassment and bullying. I don't believe this is in the best interest for my child to be with this person as they continue down this career path. Now you can argue, my kiddo enjoys the arts. I don't know. That's a tough argument. I'm sorry. I don't know.
That was a reach. You're reaching a little bit.
Yeah, okay. Well, not the arts, but at least art supplies. And this job gives me the resources to give him crayons and coloring books. And if respondent or petitioner would pay his share, then perhaps maybe I wouldn't have to do what I'm doing. But it seems as though this is a last option for this person. So I don't want to cast any judgment. You're not knocking anybody over the head. So we're appreciative of that. But if indeed that is the only way you know how to get it, be safe and provide for your children. But just know, many an attorney is going to take this profession, blow it up, perhaps not use actual footage, but definitely use it to their advantage.
So Floyd just wanted everyone to know that he's used OnlyFans twice. He commented.
Yo,
He says, I have used it twice.
Things you shouldn't brag about, Floyd.
yeah, really. Just FYI, since you're on the subject.
So I think that what he was trying to say was that he's tried to use the OnlyFans argument twice against.
I don't know. That's not what he said. I think his trial membership might have just ran out.
Now he said twice per day.
Okay.
Okay, so I think that there was the case that he's talking about. And I think it was an OnlyFans thing, but we never accessed the OnlyFans account. Neither one of us were brave enough to do that. But this particular mom had a bunch of stuff on her, I want to say it was like Instagram and Facebook. He said it was, yes, I think, stop reading my mind. And so we went through all of that stuff, and it was really kind of weird because this mom, she's a beautiful, beautiful lady. And she would do like these kind of like videos or like live streams and stuff. And she'd be in like really, really like hardly any clothing at all. And some of them, she would have the kiddos like in the video, like as she's streaming something. And it was never like anything necessarily sexual. She would just be in like very, I don't know, like bikinis with everything kind of hanging out. And she'd be like, hey guys, blah, blah, blah. And then see the kiddos in the back. And then I want to say that she worked at a strip club. But she was not a stripper. I think she was just like a waitress there. And obviously our client, the dad, he was really concerned. Again, he had little girls. And so he was concerned that they were being exposed to this lifestyle, and just kind of the impact that it was going to have on them. Oh, so apparently we did get the OnlyFans. I don't seem to recall that, Mr. Floyd.
Right, Floyd.
It's also not-
Checking those hours for that week.
So I guess we'll discuss that here in a little bit.
Oh my God.
And there was
Floyd, you are
twerking,
wild.
apparently. He wants everyone to know that there was some twerking involved.
Floyd,
So,
wow.
anyway, in that particular, I think we ended up settling because of all of that. I think it's a good thing that Mr. Floyd was not on today.
Oh,
This
that's
is
good.
a hot mess, just all of it. And so, I think some judges will care, and I think that it can potentially impact a kiddo. But I also think there's some judges that are going to say it's a job, like it's a job. And as long as the kids are not around and they're not seeing it and they're not, being exposed to it, how do you prove that it is actually impacting the kiddo? And that was kind of the difficulty that we were having with that case, was making that link, because kiddos were doing great, mom was financially stable, and she was doing really well. But how did we impact that it was a negative, having a negative impact on the kiddos? It was difficult. So something to consider. Floyd, you're not supposed to cuss. He cusses on the comments when he's not here. My Lord. Okay. With that being said, I
You still messaging?
I'm gonna put up a disclaimer because we're over time. So like we said in the beginning, middle, and end of this thing, please, please, please do not accept this as legal advice. We talk through fact patterns, and as you can tell, as we're talking through these fact patterns, any little thing can impact our opinion on what could potentially happen to these people. And so if you find yourself in a situation where you might need an attorney, go and talk to an attorney, tell them your specific story, listen to their advice, and I'm sure, or not sure, I guess I'm hopeful that they will set you down the right path and they'll be able to get you out of whatever predicament you find yourself in. And with that, thank you guys for joining me today. You're so much better than Floyd. So, y'all have a good day. Bye.